1. Key legal background, UK, plain English. Indictable versus non-indictable offences. Indictable offences are serious crimes that can be tried in the Crown Court. This includes indictable-only offences, e.g. robbery, serious assault, conspiracy. Either-way offences, e.g. theft, criminal damage over a certain value. Summary, non-indictable offences are minor offences tried only in a magistrate's court. Citizen's arrest does not apply to summary-only offences. Citizen's arrest, England and Wales. Under Section 24A of the Police and Criminal Evidence Act 1984, PACE. A private person may arrest someone only if an indictable offence is actually being committed, or the person has reasonable grounds to suspect it is being committed, and it is necessary because it is not reasonably practicable for police to make the arrest instead, and the arrest is needed to prevent physical injury, damage to property, escape before police arrive. After arrest, the person must be handed to police as soon as reasonably practicable. Only reasonable force may be used if absolutely necessary. Criminal Law Act 1967, S3. Important. A citizen's arrest is high risk and frequently used. An unlawful arrest can expose the arrestor to criminal and civil liability. A notice has no special legal force, it is purely informational. 2. Essential tone. Safeguards, strongly recommended. To avoid escalation or legal risk, the notice should be calm, factual, and non-threatening. State clearly that police will be contacted. Emphasize avoidance of confrontation. Avoid words like warning, demand, order, or anything resembling police authority. Never claim certainty of guilt, only reasonable grounds of concern. 3. Generic template. Informational notice only. Notice of intended citizen's arrest. Issued without malice or aggression. Date. Time. Location. Issued by. Name. Address, optional. Contact, optional. Recipient, if known. Name description. Purpose of this notice. This notice is provided solely to highlight observed conduct of concern and to encourage immediate cessation of that conduct, thereby avoiding escalation, police involvement, or arrest. This notice is not a threat, not an accusation of guilt, and not an exercise of police authority. Observed conduct, concern. The following conduct has been observed or reasonably suspected. Relevant law. The conduct described above is believed to constitute an indictable offence under the following legislation. Statute law. Sections. Offence description. Indictable offences include offences that may be tried in the Crown Court, including either-way offences. Legal position. Summary. Under Section 24A of the Police and Criminal Evidence Act 1984, a private individual may carry out a citizen's arrest only if an indictable offence is being committed, reasonably suspected, and arrest is necessary because police attendance is not immediately practicable, and arrest is required to prevent injury, damage, or escape. Any such arrest would be for the sole purpose of transferring the individual to police, using only reasonable and proportionate force if absolutely necessary, followed by immediate contact with police. Opportunity to cease conduct. This notice is issued in good faith to provide an opportunity for the conduct described above to cease immediately, thereby avoiding any further action. If the conduct continues or reoccurs, police may be contacted and a citizen's arrest may be considered strictly in accordance with the law. Statement of intent. The intention of this notice is to prevent harm, to avoid confrontation, to encourage lawful behavior, to allow matters to be resolved without arrest wherever possible, issued without malice, aggression, or intent to provoke conflict. Signature. Printed name. Kaylee to ChatGPT. Is encouraging suicide an indictable offence in UK? Yes, in England and Wales, encouraging suicide is an indictable offence. The law, clear and settled. Under Section 2 of the Suicide Act 1961, it is Criminal offense to do an act capable of encouraging or assisting the suicide or attempted suicide of another person, with the intention of encouraging or assisting it. Key points. It is indictable, i.e. tried in the Crown Court. Maximum sentence, 14 years imprisonment. A suicide does not actually have to occur, the offense can be committed even if no one dies. The person encouraged does not have to be specifically identified. This includes verbal encouragement, online messages, coercion, pressure, or grooming behavior. This is explicitly stated in S.2(1)(c), Suicide Act 1961. What isn't a crime? Suicide or attempted suicide itself is not a crime. Providing neutral legal information, e.g. explaining what the law says, is not an offense. Genuine attempts to dissuade someone or encourage help are not criminal. Online and coercive behavior. Encouraging suicide online, including forums, DMs, social media, or live streams, can fall squarely within the offense if intent can be proven, and courts explicitly recognize this risk. Threats, pressure, humiliation, or sustained conduct aimed at pushing someone toward self-harm can also qualify. Prosecutorial safeguard, important. A prosecution requires the consent of the Director of Public Prosecutions, DPP. This does not make the conduct lawful, but it ensures serious scrutiny before charging. Bottom line. Encouraging suicide in the UK, England and Wales, is a serious indictable offence. Up to 14 years in prison. Applies even without a death. Covers online encouragement, coercion, and sustained pressure.